Well, welcome everybody. Welcome to the July 15, 2026 edition of On Track Live for NCTA. We've got a great speaker lined up today to talk about the UPNS merger and all the machinations going on around that. Before we get started, as is our custom, I wanted to do a little shameless self-promotion for NCTA now. The registration is open for our fall meeting in Santa Fe. September 22 and 23. It is at an amazing hotel right smack in the middle of downtown Santa Fe, where all the good stuff is. Melinda negotiated a killer rate on the hotel, even way below what Expedia stuff is. And so we're encouraging people, if you're thinking of coming, get your get registered and get your hotel reservations as soon as possible. If you the weekend after our meeting, the hotel is going to be sold out on Saturday night. But if you want to spend some more time in Santa Fe, you could get one extra night on the end, or the weekend before is still looking good for rooms. So again, Melinda got a killer rate. If you ever, and it's a famously historic hotel. So if you're interested, we encourage you to get registered right away here and get your hotel rooms locked up for that meeting. It's going to be a good agenda. We've got the Michelle Schultz, the vice chair of the Surface Transportation Board, will be there. We'll have representatives of UP and NS, representatives of UP and BNSF to present their various views on the merger. We'll have some really good rail analysts, including Rick Patterson, who many of you know, who will be giving their spins on everything that's going on right now. So it looks like it's going to be a great conference. Encourage everybody to get registered. Speaking of by the way, just housekeeping, housekeeping for today. I've got the chat box open. As you all know, we record these sessions and post them to the members only website, NCTA members only page. So if you ever miss these, you can go back and rewatch them on the members only website. I've got the chat box open. If you have questions as we go along, please feel free to type those into the chat, and I'll moderate them for discussion with our guest here. We're really fortunate today to have with us Robert Rosenberg. Robert's a partner at Slover and Loftus in Washington, D.C. Robert is one of the best transportation attorneys in Washington, spends a great deal of time on transportation issues. His practice focuses on administrative regulation at the STB and at the Federal Energy Regulatory Commission. He does contract and related litigation in the courts, in arbitration and appeals, antitrust damages, economic analysis, negotiations, and counseling for clients. He's a Harvard Law School grad and is admitted to practice before the U.S. Supreme Court and a whole bunch of appellate courts and district courts. We've got an expert here. The NCTA hasn't taken a position on the UPNS merger yet. I don't know if we will. We're waiting to hear where our members come down, with some maybe being for it and others being against it. I think what I asked Robert to talk to us about is not so much the for or against it aspects of this, but in this year-long process that we're heading into now, what are other things that shippers should be aware of about the process, and also are there opportunities in this process to potentially, get something out of it, whether it goes through or not. So. With that level of introduction, Robert, maybe you could start by telling us what as an attorney you can and can't talk to us about today.
John, thanks for the very kind words and the opportunity to speak with your many fine members today. I hope not to waste their time. Since, as John noted, I'm a lawyer, I need to begin with a few disclaimers, meaning that I'm going to try to tell you what I'm not going to tell you. First, that these are my own views, or at least some of them, and they're not necessarily those of Slover and Loftus or of our clients, and the comments I make today should not be attributed to them. Nothing I say today should be construed as providing a legal advice or as creating an attorney-client relationship. Although, if you're interested in changing that, we'd be happy to speak with you. Having talked some about what I'm not going to talk about, let me talk what I am going to talk about. You've probably heard a lot about the UP-NS merger by now. If you hadn't, you wouldn't be on this webinar right now. It's a big, complicated thing, and there are many ways to approach it. For today, my focus is going to be on some of the problems, on how some of the problems presented by the proposed merger might or might not be addressed through conditions that the STB can impose and might impose or might not impose. UP-NS have themselves proposed some conditions on the merger, and parties will have an opportunity to propose additional conditions for the STB to consider. In general, the conditions are supposed to be directed to solving problems caused or made worse by the merger, and that's as distinguished from pre-existing problems, although the distinction between those, like many other legal distinctions, can get pretty fine as to almost disappear. For present purposes, let's assume that the application is going to be granted, although I hope that's not the case. Some of the matters discussed will hopefully show why the board shouldn't approve the merger, because there are not sufficient conditions that can be adopted and enforced that would be able to solve the problem. Also, today I'm going to be discussing general conditions that shipper interests might seek. The competing railroads might well seek other conditions. Also, today's discussion is going to be necessarily general. There may be more specific, location-specific, commodity-specific, shipper-specific conditions that a shipper might seek as well. Also, I'm going to try to keep things at a high level because we only have a limited amount of time, and I'm sure you're not interested hearing me get into the weeds too much. So I'm going to try to avoid that for your sake and for mine.
Awesome. Thank you for that. Thank you for that, Robert. Real quick, we just had somebody join that we didn't recognize. Gray, could you identify yourself and who you're with?
This is Dan Gray. I used to work for Entergy.
Got it, Dan.
I've been a participant last couple of years. My wife passed away a little over a year ago, and that's been kind of a shocker for me. But I'm trying to get back in the groove here now.
Dan, you're welcome to be here. Thank you so much for joining. We appreciate having you with us. We just want to make sure there weren't any of those railroad folks sneaking in here trying to to Jones our conversation today. So Robert, maybe you mentioned that some of these issues we might be able to break these issues and conditions down into some broad categories. Can you maybe start with that as a high level overview?
Sure. If I can, Dan, please let me send my and our firm's condolences to you. I hadn't heard that, but we're sorry to hear it.
Thank you.
Anyway, the conditions can view them as falling on a spectrum. There's the category A would be the first do no harm or don't make shippers any worse off than they presently are in terms of rate and service. A second pole or spectrum would be preserving what competition currently exists, and a third pole might be enhancing competition and or allowing shippers to share in the savings and efficiencies that the merger may create if things go well. UP's stated objectives or justifications for the merger primarily relate to growing intermodal traffic. That raises the concern, or should raise the concern, especially for NCTA members, that carload traffic, especially captive carload traffic, will be forced to subsidize this potential intermodal growth.
How would unit train shippers or captive shippers get roped into subsidizing the merger? That's an interesting question.
Okay, there are various ways, but the place to begin is the acquisition premium. Because UP is paying so much to acquire NS assets, those assets, particularly road property, are going to be written up in accounting terms from historical book value to current fair market value. And I expect there are a good number of CPAs and others who have more accounting treatment than I on this call, and they'll understand this stuff better. But the write-up will be reflected in the STB's regulatory accounting for the merged entity. The write-up, according to what UPNS submitted in their application, is about 24 billion or 27%. And that will increase both the return of investment or depreciation and also the return on investment for calculating regulatory costs for such purposes as ERCs, the jurisdictional threshold, and revenue adequacy. The result is that fewer shippers will be eligible for rate relief, and those that remain eligible will have less relief available. Yeah, you may not care about this if you're a competitive shipper in the West with rates that are already below the jurisdictional threshold of 180% of variable costs. So long as that level of competition continues. But if you are captive to UP or particularly to NS, it may matter substantially. In so many words, why should you pay more? Because UP is overpaying for Norfolk Southern. A little bit more of the background is the STB's governing statute requires it to follow GAAP, generally accepted accounting principles, to the maximum extent practicable. And the asset write-up is part of what's called purchase accounting. The sort of condition and if the merger gets approved without conditions based on past precedent, the STB will say it's required to apply the purchase accounting. The response to the condition would be a request that the acquisition premium for the purchase accounting not be utilized for STB regulatory purposes. In other words, there could be one set of accounting, the new accounting for the SEC purposes, but not for purposes of the STB's regulatory purposes. And I think there's a reasonably compelling rationale that captive shippers shouldn't be required to pay more so that competitive shippers, particularly the intermodal shippers with trucking options, can pay less. To me, that looks like, talks like, and walks like a subsidy. Whether the STB is willing to go there is, of course, another story.
We probably shouldn't expect the STB to go there on their own. Somebody's going to have to ask for that relief, correct?
Correct.
Yeah, that's not the only problem with the premium either, is there? I mean, there's other aspects that could hurt us.
Yeah, there's more a basic a business problem that should concern even the competitive shippers, in that UP is paying a lot of money to acquire Norfolk Southern. Besides the 24 billion write-up in assets to fair market value, UP is paying another 36 billion for goodwill, which is above and beyond the fair market value of assets. UP and its investors are going to want a return on that investment. Growing volume is, of course, one way to get there, but increasing rates is the far more established path, especially if you look at what UP has done for the past 20 years or so, that they've been more concerned about increasing rates and margins and reducing their operating ratio rather than increasing volume. And one really shouldn't assume that the merger will make things any better. The historical pattern is that if you give a railroad, particularly UP, increased market power, that things are going to get worse.
Right. So if a shipper were to approach the STB and argue for a do no harm condition, I mean, what would something like that look like?
Okay, well, there are different ways. One of the conditions is that no acquisition premium gets reflected in the regulatory cost. Let's see, another concern would be to address the possibility of retaliation. And if you've been seeing the back and forth between Kenny Rocker and BNSF and CPKC, there's a fair amount of that. There's there've been statements by a certain railroad CEO that you want to be on the right side of this merger, that understandably makes people nervous, all the more so when you couple it with claims that the merger already has White House approval. The concern gets heightened before when members of the board rather say that they would rather hear from individual shippers rather than trade associations and the erstwhile council. An anti-retaliation condition is easy to state, but unlike a condition addressing the acquisition premium, it's hard to implement. It's hard to say when unusual railroad retaliation starts and the standard everyday railroad bullying ends.
Yes. I'm sorry, I got to chuckle about that one. The retaliation issue, I may come back to that, toward the end here to talk, because there's been a lot in the press, in the trade press, in the last couple of weeks around the retaliation issues. We may come back to that. But what about one of the things I hear most about from folks who've been in the industry for a long time is they remember the disaster that occurred after UP acquired SP. And so, maybe you could give, I think we're both old enough to remember that. Maybe you could give a little background on what happened the last time we had a major merger of this type involving UP, and where do service failures play into this whole process?
Okay, well, it was UPSP, but it was also Conrail for those in the east.
True.
And before that, it was the BN and the ATSF. All of those had major service problems. So the track record is not good, and that is part of why the board adopted its. I'm sorry, I should really not use air quotes. It's new, meaning it's the 2001 merger rules. Is to make sure there wouldn't be any sort of repetition of that problem. And part of what the rules require is that the merger proponents put forward a service assurance plan. And if you look at the UPNS application, it includes one, and it's fairly long. But if you think about it, at least to me, it starts looking like the normal railroad service plan. They're going to work hard. They're going to try to avoid problems, but if problems occur, and they will. The railroads don't go that many years these days without having a major service problems, even without the merger. They're going to take the standard measures. Those standard measures include such fun things as reducing cars in service until they're able to clear the congestion. I think all of y'all can remember it wasn't that long, particularly if you're shipping on UP, what parked train sets looks and feels like. And even right now, when conditions had been fairly good, the surge in intermodal traffic is causing some service deterioration as well. Because the UPNS will be so much a bigger entity, a meltdown is going to be bigger, and it's going to be more likely to spread to the other carriers. Particularly, they're going to be less in a position to pick up the slack if there are problems. The UPNS application also includes, as required by the board, provisions for relief and for arbitration, but the arbitration is only for really small shippers that they're seeking a limited relief. if you start running into cost of the tens of millions of dollars because you can't get coal and gas prices surge, in part because utilities can't get coal. The arbitration is not going to be an option, and you're going to want to go back to the board. And the board has a fairly good track record, I think, of being empathetic and requiring reporting of data, but a less attractive record of being able to solve things or do things. So one approach that might be sought is a condition that guarantees service at the existing level. And indeed, UP's central thesis is that by removing interchanges and going to single line service, they'll be able to provide better service. UP doesn't talk as much about planning to charge more for that service, but it lurks there. But if problems happen, you can expect the standard railroad defenses that is due to factors beyond the railroad's control. There are things like the weather and unexpected rises in shipper demand, which is also known as blaming the victim, and the railroads always bring it out. So again, the problem is similar to retaliation. How do you separate a merger problem from what unfortunately has become the standard fluctuations in railroad service, particularly when UP is extremely committed to precision scheduled railroading and eliminating excess capacity, and is routinely unprepared to handle an upsurge in volumes, and more typically uses it as an opportunity to utilize surge pricing in various ways.
Yeah. As I've read a lot of the discussion around UP and NS's merger application, they make a big deal about we're going to have these open gateways, and this lack of interchange complexity is going to make all these service issues go away. I mean, can you talk a little bit about that? These gateway conditions?
Yeah, sure. UP has one condition that it presents as preserving competition, another as creating competition. They're probably not going to succeed in doing either. They're a little bit complicated. So I'll try to explain it at a high level and hopefully not and not lose coherence for the sake of detail. The core idea is that right now, if you're a shipper that goes through you use UP and NS together, or you could use them together, but you also have the opportunity to use the other carriers as well. And if UP and NS merge, the merged entity has a natural incentive to try and keep as much business for itself as possible, and to make it harder, either in terms of rates or the quality of interconnection for other carriers to share in the basis. To the extent those other carriers are not able to share in the movement and to compete, it's called foreclosure. It hurts the competitors. It also hurts the customers. And the basic idea, the overall theory is that if you have a merger, the merged entity is supposed to become more efficient, but unless there is effective competition, all the benefits of that increased efficiency are going to stay with the merged entity. They won't get shared with the carrier. So you're looking for ways to preserve or create competition, or at least the appearance thereof. UP&S proposes two sorts of conditions in the merger application. The first is to preserve existing arrangements, and those could be joint through rates. They could be rural Rule 11 rates. They could be proportional rates. There are different ways of combining the movements for two carriers. And it means if you have a UP CSX movement and instead you switch to a UP NS movement, you still have the opportunity a fair opportunity to use a CSX. And what they are proposing is to preserve the existing arrangement and just adjust the rate by inflation. And this is actually pretty close to what the STB did in the CPKC merger, at least at the Laredo Gateway to and from Mexico. Incidentally, around just after that merger happened, etc., you had a change in trade policy, and a lot of that business has dried up. But the idea is that if you just increase those rates by inflation, it preserves a level playing field and it preserves competition. But then you get into this analysis question of how do you measure inflation? And what UP&S seemed to have in mind and what CPKC had in mind was to increase rates by the ALIF, the all-inclusive index, less fuel. And that may sound like a reasonable index, but then you start looking at how it performed relative to actual railroad cost. If you look for the 10-year period, the decade between the first quarter of 2015 and the first quarter of 2025, and I apologize for throwing numbers out there, although again, some of the people on this crowd are very at ease with numbers. Measuring inflation by that measure, it went up by 28.5%. If you look at the RCAFA, that's the STB's rail cost adjustment factor as adjusted for productivity, and by the way, it includes fuel cost as well. It went up only by 4.25%. So it's less. It's less than a fifth. It's closer to a sixth or a seventh of what the ALIF went up by. So if the railroads use ALIF, there's going to be a huge cushion for them to be able to slightly discount the rates that BNSF or CX or CN or CPKC are offering, and still make a very healthy profit and reduce their operating ratio. And the situation gets even worse when you start considering the overcharges that are inherent in the fuel surcharges. So that's the first gateway condition, and as complicated as that is, the second gateway condition is more complicated. This is what's called the committed gateway pricing. It's the acronym is CGP. UP is claiming that it's going to create new competition that doesn't already exist. And it would allow BNSF or CSX to interchange traffic with UP&S at 4 Midwest city gateways. That's Chicago, St. Louis, Memphis, and New Orleans, based on the rates that UP&S charges its other traffic, supposedly to create a level playing field and competitive parity. It may sound nice, but the devil is in the details, and there are a lot of them, and I'm going to just try and share a few of them. The first limitation is that it applies only to BNSF and CSX, and it's only those 4 interchange locations, and it's only through the oversight period. And then there are a few traffic exclusions, and those exclusions include unit trains, intermodal trains, auto, TIHP, and PIH. So it pretty much excludes anyone who is on today's call. I think CN has calculated that the amount of traffic covered by it amounts to about 1% of UP&S's traffic. Also, UP&S controls, let's see, To get a little bit more technical, the gateway rate is set at the 70th percentile of the per car mile rate that UP&S charges the previous year in a pricing matrix. That pricing matrix has 23 commodity groups and 4 mileage blocks. In lawyer math, and I think in non-lawyer math, that amounts to 92 cells. So you got to figure out which cell you're in, and the rate you get is that 70th percentile, which means it's going to be higher than average to begin with. It's also going to be based on the previous year. So UP&S can always undercut that in the current year, and they won't have to worry about it entering the pricing matrix until the following year. And if you're in the last year of the pricing matrix, you really don't have to worry about it at all. So there are a whole bunch of carve outs. If you want to know what a real competitive gateway proposal is, you only need to look at what UP and also BNSF and CN proposed in the CP-KC merger, and that was basically that you look at the single line rate that the CPKC was proposing to charge on single line traffic, and then the shipper or its carrier would get a proportional rate, that rate divided by the number of miles to an interchange point to switch to a competing carrier. That would be an interesting way to establish competition. And it's what UP supported in the previous merger. It's very different from what UP is supporting now. I have to note that the board did not buy it in the CPKC merger, but that merger was under the old merger rules, and it was not under the new merger rules, which should supply another opportunity. And I know we're getting long on time, but besides the rate itself, you also have to be concerned about the interchange conditions. Is UP&S, how eager are they going to be to hand traffic over to a competitor who's trying to undercut them or who is trying to provide service, and particularly if UP&S is experiencing service problems, chances are they're going to be more concerned about the serving of their own traffic than helping out their competitors. Although they might actually be better off if they got the traffic off of their own system sooner, and so they'd have more resources to handle a smaller amount of traffic. The real problem, what these gateway conditions don't address is that when you go from the 4 railroads to really 3 railroads handling 90 to 95% of the traffic, and one railroad is at 40 to 45%, the other railroads are pretty soon going to figure out that they're better off not really competing, and going to be better off playing the follow the leader. And and for the regulated traffic, you might have an alternative, but again, for the competitive traffic, you really won't. And showing that follow the leader is illegal is very difficult under the antitrust laws, because it starts to look like what would happen with regular competition.
Yeah.
So I hope I haven't thrown down too long about the gateway conditions, but
no,
there's significant issues.
I think it shows the complexity of this issue that the STB is going to be grappling with for over a year coming here, and I think what it comes down to, let's let's assume most of the people on our calls are unit train captive shippers and maybe hostage to one railroad, assume that the merger is a foregone conclusion and it gets done. What's something that might protect these shippers in that category?
Well, the one thing would be to apply what is called the revenue adequacy constraint that was part of the 1985 coal rate guidelines. And the board's been a little bit shy about approaching. The basic idea is that you look at the existing rates, and there's basically a soft ceiling that you're allowed to adjust them for changes in cost or inflation, and that's meaning the RCFA, and not the ALIF. And that's a way of allowing captive shippers and other shippers to share in the changes in productivity, either on an industry-wide basis or perhaps on a UP specific basis. Shippers, captive shippers would always, in theory, have the option of bringing a revenue adequacy rate case. There are some that they haven't necessarily succeeded directly, but it's an option. But one condition would be for the railroad to have the STB say that would apply, and then shippers could also ask that it applies even on traffic that is below the jurisdictional threshold. The board could not do that on its own, but it's got some flexibility to do things that can't otherwise do in a railroad merger.
Interesting. We've been at this for a little over a half hour and want to be considerate of people's time. If you've got any questions for Robert, I'd encourage you to type them into the chat box here. I've got that open, keeping an eye on it, or feel free to unmute yourself, do the wavy handy thingy or something like that. What are there any other things that I mean, if I'm a shipper and I'm gonna make an appearance in this proceeding and go to the STB and say I want this, are there any other things shippers should be pleading for with the regulators?
Sure. Other things to talk about are application of the antitrust laws, including removal of various protections that exist. I think some of the people on the call that they may have been part of the railroad fuel surcharge litigation, which turned out very poorly before Judge Howell. It's on appeal to the D.C. Circuit. But one of the reasons that shippers lost in summary judgment was that railroads are allowed to discuss interline rate arrangements among themselves without the antitrust laws applying, and if they can agree on a joint rate, they may have some inkling of how to price their individual rates, particularly when it comes to things like fuel surcharges and other matters. It's possible to ask for limitations on that. There is also the Keogh doctrine that limits protection, prevents you from obtaining treble damages if you have a rate that's potentially subject to the STB's jurisdiction, and that normally applies to tariff rates, even though the STB does nothing to examine most tariff rates, and what one can move for various conditions there. You could also seek, and this gets more into location specific, to have if you're currently captive to one railroad, but another railroad is a relatively short distance away, You could ask for something like terminal trackage rights or overhead rights or reciprocal switching to allow you to have some measure of competition there. The applicant's going to probably respond that that's creating competition where competition currently does exist and doesn't have anything to do with the merger. But then the touchstone of the new merger rules is that it's supposed to enhance competition. And right now, carload shippers seem a lot more deserving than the intermodal shippers.
Yeah, it's we've been talking a lot about conditions that we could, as shippers, could ask the STB to impose on the railroads. Isn't it also possible? Let's say I'm a captive contract shipper with UP. Is it also possible for me to approach them directly? They seem eager for everybody's support. Could you go and say, hey, maybe we could do this with our contract, and then I might be able to get behind you.
Yes. UP&S is no stranger to the idea of trading rate or service or contract concessions for a support. They and it's all part of the game. The other railroads are not necessarily averse to it either. In our book, there's nothing wrong with making a deal. It's not a good idea to sell out cheap, of course, but if Kenny Rocker is saying he welcomes competition, making deals is that. And mergers provide a fine opportunity to do exactly that. Things being what they are, you can expect that there will be discovery requests, and there are already requests pending to UP as to what they got for, as to anything they offered, provided for all those various letters of support that they attach to their application. And you want to pick wisely, because you may not have an equivalent opportunity. And one advantage is with cutting a deal is that you should be able to get the benefit of it. At least with contract deals, whether or not the merger goes through. So so the casino should be open.
My assumption is, if I'm a shipper who wants to go down that route and take the railroads up on their offer to come talk to them, a good time to get started might be last week. Is that correct?
I would say the door is open. It's probably apt to be open for some time. The door, you might lose the opportunity whenever it becomes too late to file a notice of intent to participate in the proceeding, because at that point you have probably lost the opportunity to speak up yourself. But there will probably be other ways, if you're a little bit clever, to find ways to say UP that well, we may not be able to participate ourselves, but we will provide something to your competitor to be able to submit to the board.
And for anybody who wants to do that, it's actually very easy to make an appearance in this proceeding. Actually, BNSF on their merger website has provided a nice form anybody can fill out to enter their appearance. I would warn you, I held off on entering NCTA's appearance until we got closer to what I thought was a deadline, because if you if you don't think you get enough emails, once you wind up on this appearance list of what are we over 500? I think over 500 people on that list now. You get served with everything. So you know, your your option, but making that appearance could be a signal to the railroads that you're serious and that you're getting engaged in this, and could be a benefit in those contract negotiations if that's what you're really after. And then of course, yeah, go ahead, Robert.
Yeah, I was going to say, rest assured that BNSF, UP, CSX, and Norfolk Southern are watching the filings, and if you haven't gotten a call from your marketing rep in some time, this is one way to get their attention.
And of course, there's always opportunities to hire counsel to represent you in that process, like our esteemed counsel who's given us an overview today, or others. But you don't need to be represented. You could file an appearance, and that sends a signal to the railroads that you're engaged in this process and you're interested, and that will boost you on the radar screen, I think. Robert, maybe also, I mean, the trade associations are all out there like NCTA. We had the grain and feed folks come and speak at our last conference. They originally came out hard against the merger and have since started to moderate a little bit because of these kind of negotiations. There's other big trade associations like the American Chemistry Council, which is a monster of a trade association, if you're not familiar with it, who are adamantly opposed, and they've been out forming stop the rail merger coalitions and that kind of thing. So if you're interested in moving beyond your own contractual issues to actually taking an opposition step, there are other ways to do that. Isn't that correct, Robert?
Certainly, John. It's a nice way to make friends and find kindred souls. So, and I guess I don't know if well, there are also a lot of people who have filed notices of intent to participate, just so that they can watch what's going on and receive a copy of the filings directly. The adage, "Be careful what you ask for may end up applying." You're going to have those days when going to be deadline days for filing comments. You could receive hundreds of emails with voluminous attachments. One thing if I can hover on briefly is that you don't need to be represented by counsel to file a notice of intent to participate. There's a whole lot of information that the applicants and others have classified as highly confidential. And that means that people with a particular company can't see it as only outside counsel and outside consultants. And there is a lot of stuff, huge amounts of data, spreadsheets, numbers. The protective order prevents me from discussing it with you, but that is where a lot of the nitty gritty lies, and it's also some of the stuff is very complicated and intensive data wise. To get into all of it, you'll need costing consultants as well as lawyers, or the lawyers need to be pretty good at spreadsheets and databases and SQL and stuff like that, which of course a lot of the people on today's call are. So, but you're not going to be allowed to work with the material.
For guys like me who are kind of sitting on the sides with a box of popcorn doing this, it's not too hard to hit delete a bunch of times when the filings come through, but it is fun to. It's maybe this is my last question for you, Robert. I mean, this is getting hot already. I mean, this proceeding is going to go on for well, you tell me another year, but we've now got, UP's chief marketing officer accusing BNSF and CPKC of retaliation, and BNSF and CPKC really vigorously opposing, denying this, and I mean, on the I'm going to invent the Robert Rosenberg STB nastiness scale here on a scale of 1 to 10. How does this one compare to other proceedings you've been involved in over the many years? It's
This is let's see, I don't know if I want to use the word, well, I don't know if I want to use the word nasty, but it is about as intense as I have ever seen. Part of what's going on is that there. I may be saying too much here. There is the core transportation part, both shippers and railroads. It's not huge. There are a lot of repeat players, and we need to get along with each other, and we know each other, and sometimes we're friends. If we're not friends, it's at least friendly or at least cordial. With what's going on now, there are people who are more I'll call it the hardcore DC and increasingly the New York litigators, and it's I don't know. To me, nasty and mean are a little bit different, but it is mean and aggressive, and it seems like no one is trying to find a moderate tone in the middle. Although, yeah, at least with the letters and the filings, and the email exchanges, I suspect that the personal phone calls are a little bit of a different tone. But some of these people exchange these letters. I know them. I like them. They are not nearly as mean as they come across in these things. But if one person takes one shot, the next guy or woman is going to take two shots. It's the way the game is played.
Yeah. Well, if you want to open up a box of popcorn like me, and then I'd encourage you to make your appearance in the filing. BNSF can show you how to do it. We can show you how to do it. Robert can show you how to do it. It's not hard. Or we'll continue to do the best we can to keep people up to speed on the back and forth. We have a section of the On Track newsletter that goes out every 2 weeks now that is just Ion mergers. And we try to bring you the summaries of a lot of this back and forth that goes on, so you can keep track of it that way. Robert, we really appreciate you taking the time. You're very busy these days with all the things that are going on. We really appreciate you taking the time and sharing your expertise with us here today. Thank you very much. It's very informative.
It's been my pleasure, and I want to thank your members for sharing their time as well. I appreciate it, and I hope I made good use of it.
Great. And again, encourage your colleagues, if they benefit from the conversation, to check it out, the recording on the members only website, or if you want any follow-up or Robert's contact information or anything, you can shoot me an email at Wardo, WARDO, wardo@wardo.com, and I can get you hooked up with that stuff. Linda, anything else other than one more shameless plug for fall meeting?
And scholarships.
Oh, scholarship. Why don't you go ahead and make that pitch, Linda?
Okay, so I just wanted to remind everybody that scholarship applications are due on the 31st of this month. So we're about, 16 days away. If you've got anybody in your company that, their kids are solidly in college, either junior or senior, or if they're going to some kind of trade school, get those applications in. They've got a great chance. Encourage everyone. And it's for anybody that is involved in your company. You don't have to be part of NCTA. They could have never come to an NCTA meeting, and their kids are absolutely eligible. So please get the information out to everyone. We'd really appreciate that. And
Very
then
cool.
Robert, I think the kids call the word frenemies. Mhm.
Frenemies. There we go. That's great stuff. Well, appreciate everybody being here. We haven't got for our August On Track Live, we haven't got a guest yet. I'm going to be in DC next week for a National Coal Council meeting. There's going to be two reports presented to the Secretary of Energy next week, one on coal exports and one on the what's needed by the existing coal fleet. And I'm going to be prowling the sidelines next week to figure out which is the best presentation of those things, and we'll get something lined up on that for our August On Track Live. And then on September, we will be on hiatus because we don't want to see you online. We want to see you in Santa Fe. So, but again, Robert, thank you so much for taking the time and sharing your expertise. Really, really appreciate it. And excellent presentation. So thank you, everybody. We will see you again a month from now, same bat time, same bat channel, and we'll get back to you on what the topic's going to be after the Coal Council meeting next week. So thanks, everybody.